Burning questions.
Insightful answers.
Listener's choice.
With Clement Manyathela.
On our Listener's Choice feature today, we are looking at the issue of self-defense and how valid it is as a defense in law. One of our listeners has asked that we discuss this, and I know there are some of you that have found yourselves in a situation where you felt the need to defend yourself, and maybe during a break-in, maybe during a confrontation, or even a public altercation. And in those moments, often instinct takes over. But once the danger passes, the question then becomes, what does the law actually say about your actions? What are the actual legal limits? When does defense become unlawful? I mean, in South Africa, self-defense is quite a complex area of criminal law. Yes, it recognizes that you have a right to protect yourself, your loved ones, or even your property from unlawful attacks, but that right still has limits. Right? The law looks closely at whether the threat was immediate, whether your response was necessary, whether the force you used was reasonable under the circumstances, etc., etc. So I want us to look at what the law actually says so that you know next time when you want to defend yourself, even though I know when you are in that moment, you're not thinking about, oh, how am I going to be able to explain this in court? Because the instinct says, defend yourself. Have you ever acted in self-defense, and how did that work out for you? I would like you to share your experiences with us on 011-883-0702. WhatsApp's on 072-702-1702. Nthabiseng Dubazana is the director at Dubazana Attorneys, who's joining us now on the line. She's going to guide us through this conversation. Nthabiseng, thanks for making time. Good morning.
Good morning, Clement. Thank you so much for having me.
Can you just start by explaining in simple terms what the law in South Africa says and how it defines self-defense?
So self-defense or private defense is wherein you are protecting not only yourself but another person who is in immediate and direct danger from another individual. So if I were to make an example, you are probably driving in your car and you see somebody who's about to hijack you, and then if you are a licensed firearm holder, then you are able to pull out your gun because you can see that somebody is pointing a gun at you as well. So to protect yourself and to protect your property, by the way, private defense also extends to your property as well. It doesn't end at just a person or the body. So anyway, you're protecting yourself, you're protecting your vehicle. You are permitted to retaliate with the same kind of weapon, which is the gun in this situation, and protect yourself. Let's say a friend, somebody you know, or even a stranger, you've seen that they are in trouble, they're being attacked for one reason or another. You are able in our law to step in and protect that particular individual. But as always, there's always howevers in the law. You're not permitted to go beyond certain aspects for you to be determined to deal with self-defense.
Well, what are some of those limits? Because many people believe that self-defense means you can just respond to force with force, right? What are the actual legal limits? When does defense then become unlawful?
I'd actually like to use an example of a case that I dealt with some time back. So this lady was in an abusive relationship. So over years and years and years of her being abused, this one time her husband at the time comes home, and she knows, because it's a pattern. She knows that when he comes home like this, he's going to start beating on me and whatnot. So she actually prepared herself. And then when he came in, rolling in and started to attempt to assault her, he pushed her, and then she fell to the ground, and she stabbed him on the leg. What's this? Not the thigh. The English word has escaped me for some reason. But be that as it may, she stabbed him on the leg, and he bled to death. She was then charged with murder, and she raised the private defense as a defense. And the state was saying, no, but at the time that you were being attacked, he had not actually started, he only pushed you. So retaliating with a knife is going beyond the limits or the requirements of self-defense. And she was able to show, as a result of the history that she went through, that it was justified that she acted in that manner. So I'm using this as an example because sometimes self-defense doesn't happen as a result of years and years and years of abuse. It would be a situation whereby immediately at this particular moment, Nthabiseng is attacking Clement. She has a knife in her hand, and he, being bigger perhaps, then retaliates and pushes her, but unfortunately she gets injured. Now, what does this mean? Does this mean Clement has exceeded the bounds of self-defense? No, because Clement was acting within what he saw as a danger to him. So this is an example that I give when I explain how the bounds of self-defense are, because they actually are determined, I beg your pardon, on the merits of each case.
So the law must still determine whether someone's response was reasonable in the circumstances. That becomes the crux.
100%.
Okay.
Yes, 100%.
Is there a difference between defending yourself and defending another person and defending your property, when it comes to defense in law?
Yes. So when it comes to defending yourself, obviously the danger is imminent. You feel scared. So they look at it subjectively, and then they also have to look at it objectively. So it has to be some sort of balance to see that if an objective person in your shoes would have reacted in the manner that you have, that's the first one. And then secondly, they need to hear from you as the individual, how you were feeling at that particular time, the kinds of fears that were coming out, and would a reasonable person relate to such a situation. That's why it's important during trial proceedings, especially if you're the accused, you and your attorney have to be on the same page. So if there needs to be some sort of psychological assessment that needs to be done, so that a report can be placed before the court to say, under these circumstances, it is reasonable to expect another person to react in the manner that the accused acted in, so that it can help in your defense. So that's when you're protecting yourself. And then when you're protecting another individual, you need to assess the danger is not imminent to you. So from what you observed, had you not stepped in to assist, would this person have been in a worse off situation, or would they have been able to defend themselves, or it was evenly matched, for lack of a better term? If the answer, when you look at it objectively, is that it was evenly matched, it means that it's likely that the party be charged with either assault or assault to age, depending on what happened to the assailant at the time.
Yeah. Oh, and Nthabiseng, let me put you back to the producers quickly. The line is beginning to deteriorate there. So I just want to make sure that we've got you on a good line so we can hear exactly what you've got to say. Have you ever acted in self-defense? How did it work out for you? Why don't you give us a call on 011 883 0702, or you can send us a WhatsApp voice note on 072 702 1702. And look, I know that in some cases you act out of fear, even when there isn't like an immediate attack. Like, for instance, you've got victims of ongoing domestic abuse. You have been subjected to abuse before, maybe multiple times. And then this time around, even though there was no, overt, clear attack, you still somehow acted out of fear because you had expected things were going to go worse. Whether that was going to be the case or not, like how is it dealt with in law when they are looking at those circumstances? Your WhatsApps are coming through on 072 702 1702.
Hi, hello Clement and your guest there. Can you please ask, does she mean that if a person is attacking me by the fist, I cannot use a knife or a gun, so I cannot defend myself with another weapon, a weapon higher than what I'm being attacked with? Is that what she's saying?
Thank you for your question, Nthabiseng.
Yes, actually, that's exactly what I'm saying. You need, like you were saying earlier, Clement, that you need to meet force with force. I cannot now hit you with a fist and then you now bring out a knife. And still, like I said, the law has a lot of howevers involved in it. So even if that is the situation, even if it's a man fighting a man and you are both using fists, but if we look at the body and the physical stature of the assailant, let's say he's bigger than you, and let's say maybe he's a boxer by profession and all of those things, he would be held at a higher standard versus you, the normal Joe, who goes to work every day and doesn't really work out. And as a result, it would be determined that based on those factors, it would have been reasonable for you to use a knife instead of using a fist, because if you had used your fist, you may have been fatally injured or at least have such severe injuries on you. Therefore, it would make sense for you to retaliate with a knife. So it always depends on the circumstances of each case.
I see. So what happens when I was saying earlier that in some instances, people are acting out of fear, even when there isn't an immediate attack. Like, for instance, if you are constantly subjected to domestic abuse at home and you, out of fear, even though there was no immediate, clear, overt attack, you respond because you were fearing that it was going to get to a point where there's violence, because that's what has happened historically. How do you argue that in court?
So just like the example I gave you earlier, which is the angle that we took when we were arguing for the accused, to say that it cannot be that she murdered her husband, because murder means the intentional killing of another human being. So whether it's premeditated or whatever, there must have been intention behind it. So in this situation, our argument was, every single Friday, when he comes back drunk, he beats on her. Here's the proof. She's got J88, blah, 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 blah. And after that, we were able to show the court that from her perspective, her deciding that today is not going to be the day where she subjects herself to that kind of assault, and her retaliating and stabbing him in the leg was tantamount to self-defense. So now the court now had to look at whether or not the fact that he ended up dying as a result, what would fall within the ambit of murder. So what ended up happening in that particular case is that when she stabbed him in the leg, she cut one of these big veins that have a lot of blood that goes throughout the entire body. So that's how he bled out and died. So the court said there is no intention, because nobody thinks that if I stab you in the leg, I'm going to kill you. What I'm trying to do is make you immobile so that I can run away. And the court then cleared her of murder and also culpable homicide, which is a competent verdict for murder. And then she was found to not be guilty. So, like I said, with such a situation, you're able to argue it in court. It is up to the presiding officer to accept your argument. But I do understand that some presiding officers may not see it that way. So each case has to really be decided on its own merit.
So, do you have to try run away first before defending yourself? Or can you immediately, as soon as you see you're in danger, the first action you take is force by force, return force with force?
So the real thing is, cowards, the quote goes, cowards are always going to be safe or be alive. So if you are able to run away from the situation and this person keeps coming at you, then you hit, especially if you're lucky enough that there are witnesses to this event. They can say, no, Nthabiseng actually walked away. Nthabiseng started to leave the scene, but this particular individual was always coming behind her, and this is how this happened. Then you can show that I was not the perpetrator. I was unfortunately the one who was found in this situation, and as a result, I'm the one who now has to come and defend myself. So yes, if you can, if the situation permits you to, try and walk away. If the assailant does not let you walk away, it gives you more grounds for your matter to be heard as one of self-defense.
Oh, I see. Here's what's a voice note that's come through.
Hi, Clement and the lady there. This is very interesting. In a situation where you are being attacked, what is the measure? Where is that boundary? Do you stop the action and go and calculate whether you are being reasonable? Have you crossed the boundaries of self-defense? You don't have that time to think about that. This brings me to a very interesting case in Law and Order, I think, where this guy was arguing temporary insanity. So in the moment
of action, there's no time to think. So I think that defense of temporary insanity comes in and is relevant. We cannot be overwhelmed by criminals. At the same time, then we cannot defend ourselves in law. Thank you, Sia.
Thank you, Sia. Nthabiseng?
So with us, our laws are a little bit different than American law. So if you are going to plead temporary insanity, so we're going to look at Section 76, 77, and 78 of the Criminal Procedure Act, wherein we're going to take you to a mental institution and have you assessed for about 30 days, whether it is privately or at the expense of the state, so that a professional can determine that really at that particular time, it can be that you did suffer a situation of criminal insanity for that particular moment. But if those results come back and it's a negative, then you're in a bit of a bind, because you could have done other things. In the law, there's so many other options that are available to you except having to plead in insanity. So, for example, if you ended up killing somebody, instead of it being murder, it can be culpable homicide. And with culpable homicide, 90% of the time, you're not going to go to prison. You may previous conviction, but 90% of the time, you're not going to end up in prison, depending on the circumstances. You're able to negotiate with the state, depending on the state of each case. So let's not go that route, because if the report comes back and says you were saying you had what we call criminal capacity at the time of the commission of the offense, you may just be tried for the murder, for example, when you could have been tried for something like attempted murder or culpable homicide.
Okay.
Morning, Clemza. The law is very grey in these areas of self-defense, self-protection, and the type of force that you can use. But I think at the end of the day, Clement, to simplify it, it all depends on who can afford the best lawyers. If your lawyer can argue a good point, you've got a strong legal team, you shot someone that was in your yard, you can say I was in danger. But if I don't have money, then I shoot someone that goes into my yard, they can say, no, you are not in danger. So it all depends on who's got the better lawyers.
Another one here, Nthabiseng says, the question says, what happens if a person believes that they're being attacked, but later it turns out that they were mistaken, but in that moment they believed there was an attack?
Well, see, that's a very nice question. So if I were to answer it, let's look at what's this robbery with aggravating circumstances. So that is when you are perceived robbery with aggravating circumstances involve a weapon of sorts.
Oof, yeah. Nthabiseng, let me put you back. I'm going to try again. I apologize, guys, for the quality of the line. I'm told that she doesn't have power where she is, and that's why the line is not so good. There's no power. So please bear with us. We've got 2 more minutes left, and I see so many questions coming through from some of you. So I want to see if she can get through at least 3 more questions before we wrap up. There's a question that I've just asked now about, is it not going to work? Okay, the producers are telling me that the line is deteriorating further and further. Okay, I apologize for that. Maybe what we'll do is we'll have part 2. Can we have part 2 of this conversation? Yeah, we'll have part 2 of this conversation. We'll bring her back, and hopefully we'll be on a better line. We'll make sure that maybe we get her when she's in the office, so that there's an alternative should we struggle with the line. But I hope what she was able to share with you was informative in as far as how valid self-defense is, and you now understand just defense in law, and you know what to do the next time there is danger, and you know what you can expect based on your actions should the matter go to court. It's going up to 11:30.